This is exactly. I apologize, my lord. We're just trying to keep tidy the record. So, witness, in your oath, made reference to an email, defendant's email of 8th of July, 2025 to the claimant. My lord, that document is listed as number 1 in our list of documents. Yes, witness.
Yes.
And then again,
Yes,
also made
reference
to a couple of emails with an attachment or with attachment letters.
Yes, I did.
Originated from the defendant and were sent to the banker. There are 4 of them.
Exactly, yes.
So please confirm to my lord that you can see those documents.
Please confirm to my lord documents. I'm waiting for the documents to be displayed.
Can you see them?
I'm waiting for what? The documents to be displayed. The documents to be displayed. Yes, okay, yes.
Yes, yes. Confirm, that's the The second one is a bundle.
One copy. Yes.
Please, excuse me, allow the registrar to show it to the receipt identify sentence.
Yes.
Yes.
Have you identified?
Yes, I have.
Okay, please also confirm to my lord that you issued a certificate of compliance in respect of those documents.
Yes.
Okay. Now, those documents are photocopied. Can you tell my lord the whereabouts of the original?
Well, so the whereabouts of the original, right, can be made available.
What you have brought to court are the photocopies.
Yes.
Are the photocopies of this email. So I'm telling you to tell my boss where the originals are and why you are making
the originals were printed out. Because it's
let's ask the questions that you once again.
photocopy of original document.
Yes.
They are photocopy of original. Right? Then I'm asking why original. Then tell my mother why you are something not the original.
I'm struggling to hear. There's a, I think there's an echo.
Can you hear me now?
Yes, I can hear you clearly now.
So I said the documents you are seeking to tender, they are photocopies of emails. Now, tell my lord the whereabouts of the original and why you are seeking to tender the photocopy.
Okay, the reason why I'm sending the photocopy is because the originals are not, cannot be found. I can't find them.
cannot find them.
Yes, sir.
Thank you very much. Now, seek to tender the evidence. The documents listed as number 1 and 2 on the list of documents.
With me to have a look at it. Thank you, ma'am. Lord, you are not objecting to the admissibility of these documents. Let me say, my Lord, that this witness did not make reference to these documents in his written deposition and oath. The documents were actually pleaded, but this witness did not mention them in his written deposition. As a court,
Now, since your lordship has said that, I'll just
the documents are listed. Sorry, I'm not calling this. Documents are listed A to G. But that's not how you arrange them. We may have to go to look at it.
Defense Counsel, where the documents not properly arranged, shared in accordance with the schedule of documents.
And what we have, the first document,
Mm.
standing.
Yes, standing alone.
Yes, and the second document, the second agenda, emails, and letters.
Yes.
There are a series of four of them. And the registrar informed me that she was going to take them together. They were actually separated. And
But they are not arranged properly as contained in the schedule here. This one starts with E, F, C, D, D. D3. 4. Email correspondence dated the 23rd day of December 2021, marked as Exhibit D4. 5. Email correspondence dated the 10th day of September 2025, marked as Exhibit D5. 6. Email correspondence dated the 23rd day of December 2021, marked as Exhibit D6. 7. Email correspondence dated the last day of September 2025, marked as Exhibit D7. 8. Letter of termination of appointment dated 23rd day of December 2021, marked as D8. The content of all these documents are to be taken as duly read in accordance with Evidence Act.
So I just want to get it. The letters of termination addressed to
The one marked so in accordance with the schedule.
my lord, even in front loading, we front loaded about 4. That's my challenge. They accompanied each of those emails. As copies. Yes. I'm grateful, sir. What happened is that we sent emails and then we attached letters. So we printed the emails as well as the letters that were attached. Sorry? Mr. Yogo, we are just these are introductory matters. I'm not giving any evidence. They are introductory matters. Yes. Mr. Witness.
Yes, sir.
Can you hear us?
Yes, I can hear you.
Please tell the court what you want in respect of this matter.
Okay. What I want in respect of this matter is.
Can you speak up, please?
Okay. Can you hear me now? Can you hear me clearly?
We object to that line. Yes. What the rules of court stipulates that other than disputing the position of those, that he's not allowed to alter or add anything outside what is stated in the written position. That's right.
As court pleases. My lord, this. What do you witness? What do you want the court to do for you in this case? My lord, this is general and very elementary.
I want the case to be struck out.
It does not matter. Please tell my lord what you want the court to do for you. Mr. Michael, please tell the court what you want the court to do for you in respect of this matter.
I want the case to be struck out.
As court pleases. My lord, that is the evidence in chief of the defendants. My lord, I'm grateful, sir.
I stand whether he can see me. I know I see him clearly. Thank you, my lord. Mr. Popola.
Yes, sir.
Thank you. You need to speak loud so that the court can hear you and we can also hear you because we are recording what you're saying.
Yes, so I'm speaking as loud as possible.
Thank you. In your statement on oath, you said that you're an analyst with the defendant.
That's correct.
What exactly do you do? I mean, your job description.
Yes. Okay, so I am an analyst, a senior analyst in the Department of Sales. So what I do, my daily
Take it
activity
slowly.
is...
We are recording. We are recording.
All right. Okay, so my duties is to coordinate operational activities, both in the office and on the field. So activities on the field culminates at the back office, which is the head office. And then I coordinate these activities to fulfill each of the goals or targets that they have been set to achieve.
Throughout the period that the claimant was with the defendant, you were the warehouse manager of the defendant in Kaduna.
That's correct, but with a little bit of not throughout. So I was moved from Kaduna to Abuja on the 1st of November 2021.
That's fine. That's fine. So you barely know anything as it relates the workings of the defendant, of the claimant when she was with the defendant.
No, not exactly.
My Lord said you should explain.
Okay, so the question was if I knew what the claimant was doing as an employee of the defendant, right?
Her job description and what she was doing and her relationship with the defendant when she was there, because you were in Kaduna. You moved into Abuja in November and she left in December. So you barely knew anything concerning her relationship with the claimant, with the defendant.
So I knew her role as the head of audit, internal compliance and control. That was her role up until when she left. With regards to the relationship, so that I can say in a space of a month is not something that I can really put, but I know that the relationship was a cordial relationship to the best of my knowledge.
Thank you, my Lord. In paragraph 3 of your written deposition on oath, you said that you have seen and read the statement of facts filed by the claimant, and that you know that the averment contained in the statement of facts are false. Confirm to the Honorable Court that you stand by that your deposition, by that paragraph 3 of your written deposition.
Yes, I do.
Look at paragraphs 1, 2, 3, and 4 of the said statements of facts. I know you have them there. Can you look at them?
I don't have them here.
Okay. I would have preferred you look at them so that we don't waste the time of the court. But if the court permits us, thank you, my noble Lord. Paragraph 1 says that the claimant avers that she's a Nigerian citizen and that she was a staff of the defendant from 9th September 2015 until her appointment was abruptly terminated on 24th December 2021. Is this paragraph? Can you hear me?
I can hear you.
Is that paragraph also false?
That paragraph is not false.
You said what I just read out now. Is it false?
It is not false.
Thank you. Paragraph 2 says that the defendant is a commodities and exchange company incorporated under the Companies and Allied Matters Act and carrying on business with its corporate headquarters at 11th floor, Tower 2, House Plot 256 off Herbert Macaulay Way, Abuja. Is this paragraph also false?
This paragraph is not false.
Fantastic. Paragraph 3 says that the claimant avers that she was offered an appointment by the defendant on the 9th day of September 2015 as an internal control and compliance officer. The claimant's appointment letter dated 9th September 2015 is pleaded and shall be relied on at the trial of this suit. Is this paragraph false?
This paragraph is not false.
Thank you. Paragraph 4 says the claimant avers that in the course of her employment as the internal control and compliance officer of the defendant, she was made a signatory to some of the defendant's bank accounts. Is this one also false?
So this paragraph is not false.
Thank you.
But can you hear me? Can you hear me?
No, you've answered. I can continue. Let's don't wait.
The paragraph is not false. Not all the paragraphs are false.
Beautiful.
So majority of the paragraphs, not all, is false.
Thank you, my lord. Paragraph 7 says that the claimant states in furtherance of the assurance of removal of her name as a signatory to the defendant's account, a copy of the defendant's letter to the Securities and Exchange Commission notifying them of the claimant's exit from the company's employ and removing her name as their compliance officer was forwarded to her. That forwarding of that letter, is it false, this paragraph? The forwarding of that letter.
The forwarding of the letter to the claimant or the forwarding of the letter to
SEC? To the claimant, because she has it and she exhibited it.
Okay, to the best of my knowledge, based on record, it is false. What we have is it was sent to SEC.
Okay, she didn't get it. She manufactured the one she tendered before the court. Is that what you want the court to believe?
So like it's based on the records that I have, based on the record available to me.
Thank you. So I will be correct to say that your paragraph 3, the paragraph 3 of your written deposition is false and misleading.
No, it's not.
Thank you, my lord. It is correct that communication in the defendant's company, your company, is either in writing or orally done.
That's not correct.
You say it's not correct. Oh.
That's not correct.
Please tell the court what is correct.
So communication in the company is solely written.
Thank you. You've come to lie to the court. My lord. Counsel, please sit down.
You can't tell me. That's very
You're disrupting.
and you did for us. My lord, my lord friend just said that you have come to lie to us. My lord, that's please. Not intimidate the witness. The witness was here, she answered left and right. Then you're saying the witness is lying.
As the court pleases. As the court pleases. My lord, we are grateful.
Yes.
Thank you. Thank you, my lord. Now, Now, in paragraph 19, you said that communication is solely in writing. In paragraph 19 of your written deposition, you stated, I don't know if you have it there, I believe you have it there, but if the court permits me, I can read. Thank you, my lord. I know that the averment contained in paragraph 19 of the statement of facts are false. In response to the said averment, I know that prior to the receipt of the claimant's solicitor's letter, the defendant has reached out to the claimant herself, as stated in paragraph 12 and above, and 16 above, and explained in details the circumstances relating to garnishee order NISA, including steps being taken to set aside the order NISA. That is the motion on notice to set aside the order NISA. Had been filed, that is that a motion on notice to set aside the order NISA had been filed on behalf of everyone affected by the order. It is correct that this explanation was done orally.
That's not correct.
Thank you.
That's not correct. This explanation was done
wait now.
Via an email. It was done via an email by the Vice President, Audit Risk and Assurance.
You do not have any document in relation to this explanation you made mention of in paragraph 19 of your written deposition?
I do.
Before this honorable court?
Yes.
Please refer the court to it.
It is Exhibit B.
Exhibit what?
Exhibit B. It was labeled Exhibit B, I believe, but it is in court.
Thank you. My lord, I call for Exhibit B. Humbly. While we are waiting for Exhibit B, my lord, thank you, my lord. I wanted to show him or for him to. While we are waiting for Exhibit B, Mr. Popola.
Yes, sir.
In paragraph 20 of your written deposition, you stated that I know that the averment contained in paragraph 20, 21, and 22 of the statement of facts. Okay, that's where you stopped. The inquiries contained in the claimant's solicitors letter were the same as the one made by the claimant herself to the defendant. Do you have any document showing that the claimant made an inquiry herself to the defendant? Because all the documentations, all the interactions with the defendant are in writing. Do you have anything before this honorable court showing the claimant's inquiry to the defendant? I don't know if my lord.
So, sorry, sir.
Because your explanation was, according to you.
Sorry.
Yes, I'm telling you that your explanations, they are. And do I take?
Yes, please, because you buffered for a while. I didn't just.
An inquiry made by the claimant herself to you. That is what you stated here. If it is not, you correct again. In paragraph 19 and 20.
It's frozen again. Please. Please, can you hear me?
Can you hear me now?
Yeah, I can hear you. I can hear you now.
Okay, thank you. I said that in paragraph 19 and 20, you said that the defendant communicated and explained in details to the claimant following the claimant's inquiries, the order of court, the order NISI. I'm now asking you if you have any document showing that inquiry, personal inquiry by the claimant, as you stated here, and your response,
I do not have
detailed explanation.
I do not
because
have,
all communications, according to you, are in writing.
I do not have a personal inquiry. What I have is the communication that was sent to her by the by the solicitor, our lawyers.
Okay, the communication that was sent by your lawyers. Fantastic. I don't, my lord, if my lord gets it. Thank you, my noble lord. You also do not have before this honorable court that communication that was sent by your lawyer. That is also correct.
Sent by her lawyer to us.
Okay, okay, is it the one the lawyer sent? The claimant's lawyer sent we are referring to?
Sent by her lawyer to us.
Okay, okay. So other than that one, which is documentary, you know, you said that before that letter came, that the claimant had earlier reached out to you, the defendant, and that you took your time to explain in details the circumstances surrounding the other NISA. So now I was asking you whether this explanation was also in writing. You said yes. I now said, can you show the court that document? Is it before the court?
The document is before the court.
Please, which of the documents, as has been admitted by the Honorable Court, is the one containing the inquiries made by the claimant?
My lord.
Please now.
No, my lord. The witness said he does not have that document. He has said it. No. There is no.
Allow him now.
Yes.
The court has admitted a number of documents. Please point out to the Honorable Court the document containing the inquiries personally made by the claimant to the defendant.
There is no personal inquiry by the claimant.
Okay, there's no personal inquiry made by the claimant.
Yes.
Thank you. So it is correct to say that your paragraph 19 and 20 are made in error.
So they are not made in error.
As the court leads it.
They are not made in error.
Let's proceed. It's okay.
What I want to make clear, they are not made in error.
It's okay.
There was a communication.
You know one
us,
Adeseju?
the claimant.
You know one Adekunle Adesuji or Adesuyi, sorry. Chief Financial Officer of the defendant.
Yes.
You are not in the same department. Your department is sales department, according to you. You are not in the same department with Adekunle Adesuyi. That is correct.
That is correct. I'm not in the same department, but we have.
No, it's a simple question now. He said that he said that he's not. He said.
You're not allowing me to finish my sentence, sir.
I don't know if my lord got it. Okay.
We do not work in the same department, but as an organization, there's a coordination that we have.
My lord, you said they do not work in the same department.
We have records of everything that we do as an organization.
It's fine.
If I
It's
don't
fine. It's
work-
fine.
Let him speak. We have records of everything.
Witness, can you answer again?
Answer. So my lord, Sanchez, I repeat your question, what you just said, so that my lord can record it.
Question. So the answer that I'm giving is that we do not work in the same department, but there are records that we share as an organization.
Okay.
Yes.
That's okay.
And I've gone through most of the records.
Fantastic. You do not have before this honorable court, Mr. Popola, any documents exchanged between you and Mr. Adekunle Adesui. You do not have.
No, I do not. I do not.
Huh?
I do not have.
Okay.
But I have records of the company, not of Mr. Adekunle Adesui.
Thank you, my lord. Do you know one piece, Adeoye, the legal advisory of the defendant?
X, yes, I do. She has left.
Okay. You do not work in the same department with Peace Adeoye. That is correct.
I do not work in the same department, but we have share records that I've seen. We coordinate on organizational operations.
You do not have before this honorable court any document shared between you or even with the defendant before this honorable court.
Between
You do
my
not
personal
have. Hold on.
I need,
so that
clarity.
Yes, thank you. You do not have any document shared by Peace Adeoye, either between you or either with you or the defendant.
No, I do not have that in the court. But I have the records.
But I have the records. These two officers are far your senior and do not report to you. That is correct too.
That's correct. They do not report to me.
You said?
Did you get me?
Hello?
Did you hear me? I said
No,
that.
repeat so that the court will hear you.
I said that they do not report to me. However, all their activities are documented in a company archive for record purpose. They are both currently not staff of the organization.
The question is simple. Because you do not report to these people do not report to you, and they are far your seniors.
Yes, that is correct. However, their activities and operations are documented in an archive in the organization for record purpose that I have seen and reviewed. Sorry, if I cannot hear you if you are speaking. I can't hear anyone.
Can you hear me now?
Yes, I can hear you now.
Okay, that on leaving the defendant's employer, I was assured by the management of the defendant that my name would be removed as a signatory to the bank account of the defendant.
Sorry, what's the question? I'm sorry, but I cannot hear you. Please, can you hear me? I cannot hear you.
Can I go? Thank you for the kind patience of the court. That on leaving the defendant's employ, I'm reading paragraph 3 of the further written deposition on oath of Isioma Oriva Oride. That on leaving the defendant's employ, I was assured by the management of the defendant that my name would be removed as signatory to the bank account of the defendant in specific terms in a conversation between myself and the defendant's chief financial officer, Adekunle Adesuyi. Myself and after my exit from the defendant, The letter informed me that all my active details with the defendant had been removed, including my details as signatory to the defendant's bank account. Can you hear me?
I can hear you.
Good. I also had a similar conversation with the defendant's associate legal advisory, Peace Adoye, with respect to the removal of my name as signatory to the defendant's account. And it was in the course of that conversation that the defendant's associate legal advisory, Peace Adoye, forwarded to me the defendant's letter to the Securities and Exchange Commission and the response letter thereto. It was based on that conversation that I believed that my active details with the defendant and third parties had been deactivated accordingly. The question now is, because you said that everything is documented, you do not have any single document before this honorable court to show that this statement as contained in this written deposition is not borne out of your document in the company.
I don't have.
I don't know if my question is
yes, your question is clear. I don't have this record. I don't have this document. I'm not aware of this conversation.
He's not aware of the conversation. Thank you. Thank you.
It's not documented. It's possible that it's not documented, and I don't know.
Okay. I'm not aware. So don't guess.
It is not documented. It is not documented.
Thank you, my lord. In paragraph 7 of your written deposition, where is it? You stated, I know that the defendant, that the averment contained in paragraph 7 of the statement of fact are true only to the extent that the defendant notified the Securities and Exchange Commission of the claimant's exit from his employment in accordance with the Securities and Exchange Commission's rules. I'm aware that the defendant's notice to the Securities and Exchange Commission was not in furtherance of any assurances to the defendant.
Yes, that's correct.
It is correct, you know, that that document was forwarded also to the claimant.
I don't have that. I don't know it. I don't
have that information.
I can't say if it's forwarded to the claimant.
You don't have that information. Thank you. You don't have all those information, all those pieces of information, because you are far a junior employee, as at the time these interactions were taking place.
That's not correct. It's because it is not on document.
Thank you. You said that your explanation to the defendant, sorry, to the claimant, as to the circumstances surrounding the organizer is as contained in your exhibit B. It is written here, exhibit A, exhibit A. Let me just make it clearer. It's a letter forwarded from Isioma. Okay, it's an email forwarded from Isioma O. Oride on 8 July 2025 to Michael Oshinao. You remember that? You remember that email, right?
That's correct. Yes, I remember it.
Please take a look. I know you have it there. Take a look at that document and show the Honorable Court where you explained to the claimant that you have taken steps to set aside the order, including filing of a motion on notice to set aside the order. Please, you can read out so that the court can hear you.
I don't have the documents here, like I said the other time, but to the best of my knowledge, it's contained in that correspondence.
Okay. Okay. It contained the fact that the motion on notice has been filed to set aside the order, right?
To the best of my knowledge, yes.
Well, that's the document marked Exhibit A in the schedule of documents front-loaded by the defendant. Thank you, my lord. My lord, may I humbly apply for other documents that have been admitted? Thank you, my lord. The documents, the email, front-loaded as Exhibit B. Exhibit B. Okay. The date here is 11th September 2025, as recorded by the Honorable Court.
Yes.
It is from Zera Kegama of FX Nigeria Limited, and it is. Are you looking at it?
I don't have the document with me here.
Okay, you needed to have your document. But it's fine. Okay, now the question is, you tendered this document to show that the claimant's name has been removed by the defendant as a signatory to the account. That is correct.
No. So
my learned friend.
Let me refer him. Sorry, my lord. Let me refer him to a particular aspect of it.
My lord, when he said that his friend is suggesting what is not.
I'm supposed to suggest. That's what examination.
Let the council take the persons.
As the court in a cross-examination, you suggest. That's what I'm suggesting.
Please go ahead.
Thank you, my noble lord. Mr. Pupola, in that document,
yes,
dated 11 September 2025, you tendered it to show that the claimant. Thank you, my noble lord. Thank you, my noble lord. It reads from Zera Kegama at FX Nigeria Limited, sent on 11 September 2025 at 10:37 to Hawa Amosa. The subject is external FX commodities outstanding document. FX. I now see Union Bank. After Union Bank, you have regards. Others are just merely email. But what the body of the listing says, good morning, Zera. We process as advised. Thank you. The question now is, in the body and in the entire email as contained in this Exhibit B, there's nothing mentioning the claimant or the remover or her removal as a signatory to the bank account. That is correct.
That's not correct. So there's an attachment to all of those emails that I believe is in the court. There's an attachment for every email that was.
No, the body, I'm talking about the body as seen. Hold on now, allow me.
The witness has answered. He said there's an attachment.
Allow me.
It's not a single
allow
letter.
me.
There's an attachment.
Allow me. He didn't make reference to attachment. He made reference to attachment. Thank you, my noble lord. Thank you. Stop doing this.
I'm sorry.
He's giving out.
I'm sorry.
He knows what he's doing.
I'm sorry, my lord.
He knows what he's doing.
I'm not doing anything.
He's unethical.
I'm not doing anything. The witness.
Mr. Popola, thank you, my noble lord. In the body of this letter, this email, in the body, the court does not know what is contained in the attachment. In the body of this email, there's nothing, not even one single paragraph or sentence mentioned the claimant or the subject removal of signatory as a signatory. That is correct.
No, it's there in the email. The subject.
Can you see it? Let me show you. I don't know how I can show him. Please look at it so that you
please
show
can
the court where it is.
Can you read
Yes.
it out, please?
No, look at your screen. Have you seen it?
Give me a few minutes, please.
Can you see that?
Yes, I've seen it.
Good. Look at it and read and show the court where the name of the claimant or the subject removal as a signatory to the account of the defendant was mentioned, as you said.
So for these particular emails and for all the other emails, right? For this one,
I just showed you a particular document. I'm clarifying him. I just showed you a particular document.
In the body of the email,
I see the
it is not in the body of the email, but is in the attachment.
At the court. Thank you, my noble lord. Take a look at Exhibit C. Okay, let me see the bit. I have it here. I have it.
I'm struggling to see because my vision is on.
He's sending it to you. He's sending to you.
All right, okay.
Can you see it now?
It's being displayed on the screen.
Yeah. Can you see it?
I'm not seeing it because I can by this thing is what is prominent on my screen. Please, can you read it out? The video is my face that is more prominent. All the other videos are just small.
Okay, thank you. Thank you. In this letter, it was sent on from Zera Kegama again on 10th September 2025 to Hawa Amosa, and it reads FX. The subject is FX Commodities Auditors Confirmation. It is addressed, I see UBA here, and regards. So the documents the email has contained does not show on the face of it that there's any attachment.
So there is an attachment.
No, on the face of it.
So the reason why you would see that
you can answer then and give explanation. Answer and give your explanation. The court is magnanimous.
There's an attachment to it.
No, I'm saying on the face of it, there's nothing showing or referring to an attachment. Only if there is, you let me know and read it out for me.
So there is removal of signatory.
I'm talking about attachment.
There is an attachment. It may not show on the face, but there is an attachment.
It does not show on the face, but an attachment. That same email confirmed that there's no response from UBA to this email. Exhibit C that you tendered.
So I don't have it in court, but we sent. Okay. It was sent.
Okay. In paragraph 17 of your written deposition on oath, you stated, I know that after the termination of the claimant's employment, the defendant informed his bankers and instructed them to effectuate the change to ensure that the claimant's name was removed as a signatory to the defendant's account. That is correct.
That is correct.
Look at your you had earlier admitted, and you also stated it, that the claimant left on the 24th of the claimant's employment was terminated on the 20th, in paragraph 4, stated that the claimant's employment was terminated in December 2021. That is correct.
That's correct.
Beautiful. Look at the exhibit D. It's a letter addressed to the manager, United Bank for Africa PLC. Are you looking at it? It's on the screen.
So I can't see it. If you could expand the video so that I can see clearly.
Can you expand it?
I can only see my face.
It has expanded it. I can even see it from here. And you see it is headed effects. In effects letterhead.
The screen is not expanded.
Is that?
The screen is not expanded. I'm only seeing myself on the screen. The other screens, the other videos are very tiny.
Thank you. My Lord has said, no, it's okay. My Lord has said, graciously allowed me to read to you. It reads, it comes under the heading, effects. There's a number there, 2215 7851 436. It is dated 23rd December 2021. Right? And addressed to the manager, United Bank for Africa PLC, UBA House Branch, 57 Marina, Lagos. Attention, Beatrice Akpan. Dear Madam, notice of termination of employment with effect. We write to officially notify you of the disengagement of Isioma Oribe as effects internal control and compliance officer. Effectively, immediately, she ceases to represent the business and all her access to her account should be rescinded. Please remove her access as signatory on all accounts with the bank. Thank you. Yours faithfully, Effects, Nancy Ochongwe. Is that clear?
That's clear.
Thank you. You have confirmed to this honorable court that the claimant was terminated. Claimant's employment was terminated on the 24th of October or December 2021. And this letter was written before the said termination. That is correct.
You said the letter was written when?
23rd December 2021, prior to the termination of the employment on record. Do you have anything to say about that?
I don't think so. I don't think so.
My Lord, I don't know.
That's a possible.
That's a possible what? Yes. That's a possible what?
I don't think so.
Okay. If you don't want to explain, I will use address to explain it to the honorable court. The court will hear me. Let's also look at Exhibit F. This one is Exhibit D. Okay, before F, let's go to E. Exhibit E. Is a letter addressed to Union Bank Nigerian PLC. And it's still the same thing, other than that, the Union Bank. Every other thing is still the same thing. And it is also captioned notice of termination of employment with effects. It is now dated 22nd December 2021. Again, I ask you, the employment of the defendant, of the claimant, was terminated on 24th December.
Yes, that's correct. Officially, yes.
Now, from the documents you submitted before this honorable court, it is clear that this purported termination were actually written before the eventual termination, the re-termination. That is correct.
That's not correct.
Thank you. The documents speak for themselves. Thank you, my lord. Apart from the letters you wrote to UBA, you
Yes.
purportedly wrote to UBA, Access Bank, and FCMB, which you exhibited before this honorable court. It is correct that the defendant had several other banks, bank accounts.
On record, she is a signatory to those 4 bank accounts.
No, answer my question. Don't set another equation for yourself. You have other bank accounts. You are on oath. You are on oath. Beautiful.
Yes.
You know that apart from Access Bank, UBA, and FCMB, that there are other bank accounts, including GT Bank, belonging to the defendant. That is correct.
That is correct.
Beautiful.
But these are the ones that she's a signatory to. There are other accounts. Please, did you hear me?
Yes, court heard you. Court heard you.
Thank you.
Thank you, my noble lord. Account number 059 493 1992 belongs to the defendant. That is correct. It's a GT account. You have all the records now.
I don't have that in my head. I don't have that account number. I don't know.
Okay, fantastic. Number 059 493 20. It also belongs to the defendant. It's a GT account.
So these are company account numbers. I don't have the account numbers in my head.
You see, can he hear me? What did you say? What's your answer?
So my answer is I don't have those. I don't have account numbers in my head.
Okay. And you don't have records of.
There are records, but I do not hold.
No, you do not have the records. You do not have the records with you or before the court.
I do not have the records of these account numbers before the court, and I do not hold the account numbers in memory because they are company account numbers.
Okay, they are company. Because you do not have those documents with you and you didn't exhibit them, you will not know, you will not be in a position to know whether the claimant is a signatory or not. More so that you do not work in the finance department.
So the claimant was only signatory
So answer
to
my question, you can explain. Answer, explain. Did you get the question?
Right. Please repeat the question.
Beautiful. The question is, you had earlier said that you are of sales department. You do not belong to, you do not work in the financial department, finance department. And you are now saying that you don't have information as regards these accounts I mentioned. They were particularly mentioned, listed in paragraph. Hold on, allow me.
I didn't say I don't.
Allow me. I didn't say so.
I said I do not hold. I said I don't have the account numbers in my head. That's what I said.
He said he doesn't have the information.
Because you don't have the account number with you or before this honorable court, and no documentation as regards that account with you or before this honorable court, you will not be in a position to know whether the claimant is a signatory to the account or not.
That's not true. Because like I said, everything that is done is documented and is archived. And these are the 4 bank accounts that the claimant was signatory to. Please, did you hear me?
Yes, we got you. The court is recording you.
Thank you.
You now mentioned that to the court that everything is documented. You do not have any documents before this honorable court from any of the banks, not even one bank, showing that the account details, the particulars of the claimant have been effectively removed from your account as a signatory. You do not have not a single document from the bank before this honorable court.
So that I don't have that with me.
Thank you.
We wrote to the banks
In paragraph
19
as
signatory
and 20 of your deposition.
We wrote to the bank to remove the claimant as signatory. It is the bank's duty to proceed based on the letters that they have received.
Finally, Popular. We also have 1 or 2 questions and we're done. In paragraph 25 of your written deposition, you stated that the defendant does not owe the claimant any duty of care. That is what you said there.
That's correct.
Hello? Please, what is the duty of what is the meaning of duty of care?
So it simply means that as a business or as an organization, we do not owe it to the claimant to explain operational procedures, especially with regards to how our organization operates, with regards to having an extra.
I don't know if my Lord got that.
Thank you, my Lord. My Lord, that is it for this. I'm grateful.
Yes, my Lord, I really apologize. I was just trying to ensure that I say but my Lord, I will miss that. My Lord, I only have one or two explanations.
Example.
As problem. My Lord, just a second. My Lord, my re-examination is on the question relating to Exhibit E. My learned friend directed the witness to a couple of letters written to the banks, particularly UBA and I think FCM. And he stated that those letters were written on the 23rd of December, 2021, which preceded the termination of the employment of the claimant. My Lord, the witness in his examination in chief, and even under cross-examination, tendered and referred to documents. I've not asked. I'm laying a foundation for the re-examination question. The witness referred to and tendered email correspondence forwarding those letters. Now,
Giving evidence from the back. This is I already explained what is giving evidence to.
No, my Lord, I'm not explaining. I want the witness.
You're giving evidence from the back.
My Lord, no, my Lord, I've not asked a question. I've not asked a question. My Lord, that's the ambiguity I want to clear. There are two positions now. Counsel, let me sit down so that you can have the floor.
Yes, I want to stand up and address the court. There are documents in both courts. And the court will look at them. Exactly.
As court, my Lord, if the court is minded that those are documents before the court, my Lord, we will leave it. All I was trying to achieve was for the witness to explain the disparity between the two. That's all I was trying to do. And my Lord, for the benefit of myself and my learned friend, I can raise new issues in re-examination if the court permits. It will only be entitled to a further cross-examination. My Lord, that's the provision of the Evidence Act, but I've not even done that. Yes, my Lord. My Lord, we'll leave it. No, my Lord, again, my Lord, my learned friend referred to those email correspondence, and he said they were dated September 2025. I've not asked. My Lord, I will leave it. My Lord, I will leave it. What I was trying to explain to is off record. So my Lord does not need to take me down.
No. You don't need to give evidence from.
No, I'm not giving any evidence. I'm not giving.
You need to explain.
Explain your. Oh God.
What he's doing is giving evidence from the back, and he knows what he's doing. He's doing it deliberately. Yes.
My Lord, I don't have process. I don't have re-examination question. My Lord, no re-examination question. My Lord, that is the case of the trial. Yeah. Yes, my lord, we had earlier spoken, and my lord, we were looking at 25th, yes, of June, my lord. It is Thursday, subject to
As a couple, my lord, we are very, very grateful. Thank you for the kind indulgence.
So, my lord,